There's still people coming. I'll sleep 2 minutes.
Yeah, apparently the lifts are not.
Oh,
Yeah,
I see.
because you know how some of them are out at the moment or something.
Yeah. Yeah, there's still people. From here. I refuse to leave to that's why I'm engaging. All right, we'll start. On behalf of the Chief Justice and the judges of the Federal Court of Australia, I welcome all of you to the Court's annual Employment and Industrial Law Seminar. I'm speaking from Sydney, the traditional lands of the Gadigal people. This has been a very significant year for the employment and industrial law practice area for several reasons. We've had the appointment of several new judges with particular expertise in employment and industrial law. This reflects the significance of the practice area for the court. It is, by a close margin, the court's third largest practice area. After declining during and after COVID, the number of matters filed in the practice area has now returned to pre-COVID levels. Victoria has returned to its traditional position as the state with the highest number of filings, overtaking New South Wales once again. This year has seen an important innovation, the General Protections List. General protections matters in the court are now triaged and initially case managed by registrars. This ensures the consistency of case management across cases throughout Australia and early identification of issues that need attention. This year has also seen a number of important judgments in the employment and industrial relations practice area. For example, among the more notable are the Corporate Air Charter case, the Retail and Fast Food Workers Union against Woolworths case, the recent Qantas penalty decision, and the Latoof decision. Now, tonight, we're expecting 213 practitioners to attend the seminar in person in Sydney, as well as 229 in Melbourne and 50 in Adelaide. And there are expected to be some 944 viewers online. I think those numbers speak to the importance of this event in the life of the court and for the practice of employment and industrial law throughout Australia. I will now hand you over to Justice Raper to introduce our first speaker.
In the context of sharpening the tools, Victoria Brigden will commence by considering the revamped whistleblowing legislation and recent authority. Her experience well equips her for this task. Victoria is a barrister of 15 years call at the New South Wales Bar, practising from 8th floor Selborne Chambers. She has a broad practice area specialising in commercial employment and regulatory matters, including matters involving the ACCC, ASIC and the Fair Work Ombudsman. I know myself that Victoria is a marathon runner and known as a child cricket wrangler and avid spectator of that sport. She will be aptly placed to introduce and to opine on this area. Please join me in welcoming Victoria.
It's a privilege to have been invited by the court to speak to you this evening with Mark and Gillian, and I'm very much looking forward to hearing from them. Thank you to Justices Rangia and Raper for your introductions and to all of you tonight for your attendance. I'm delighted to speak to you about this topic as it's a particular area of interest of mine, being an intersection of commercial, regulatory and employment litigation. The purpose of the whistleblower provisions in Part 9 AAA of the Corporations Act is to encourage individuals to disclose corporate misconduct or crime and to reduce the risks they might otherwise face from those disclosures. While the provisions were first enacted in 2004, they underwent significant amendments in 2019, which widened their scope and theoretically made it easier for claimants to succeed. Despite this, it's only in the last 2 years that the case law on the post-amendment provisions has begun to develop. No applicant has succeeded in a contested final hearing in the federal court on the amended provisions, and only 3 decisions have proceeded to final hearing and judgment in this court to date. There are as yet no decisions following a contested hearing on a suit brought by ASIC on any of the contravention provisions, although a decision on an agreed penalty following admissions of an actual victimisation contravention was handed down last week in ASIC and Terracom Limited, a decision of Justice Jackman. Hopefully you have access to a handout either electronically or if you're physically here in Sydney over by the door, which indicates where I'm heading today. Next slide, please. I'll explain how the provisions of the part work because it's not obvious from a first reading of them. And I'll do this by reference to the full federal court's decision of Watson and Greenwoods and Freehills, taking you to some of the key provisions and concepts, the contravention and offence provisions, before discussing what lessons we take from the 3 decisions of the court on the post-amendment provisions. I won't be able to explain every provision in the part in the time available, but I'm aiming to explain the key concepts most relevant to civil litigation on the provisions in the employment context. Next slide. A helpful starting point to understanding the provisions is the full court's decision in Watson and Greenwoods, which you'll see is the first case listed on the slide. This is a decision of Justices Mashinsky, Abraham and Raper on a separate question referred from a single judge, and the main claim settled prior to final hearing. The significance of this decision lies in the full court's explanation of the changes brought about by the 2019 amendments. The full court observed that the new provisions affected several material changes. I want to focus on 3 of these, which arise from section 1317 AD. Next slide, please. First, orders for compensation and other relief can now be made without any contravention of the offence or civil penalty provision being established, which was not the case previously. Secondly, it's now sufficient to establish that detrimental conduct occurred because the wrongdoer believes or suspects that the whistleblower or any other person made, may have made, proposes to make or could make a disclosure, rather than needing to establish that the conduct occurred because of an actual disclosure. Under the pre-amendment provisions, an actual disclosure had to have been made. Third, the burden of proof applicable to compensation orders has been modified such that there is now a reverse onus for part of the claim. Now, the reason why Section 1317 AD is important is that it's a gateway to relief under Section 1317 AE, which is a very broad provision, including, for example, by way of relief, compensation, an injunction, reinstatement, an apology, and culminates in any other order that the court thinks fit. This section is the only way that individuals can claim relief under the part, and applicants will only be ordered to pay the costs of the proceeding in the event of vexatious or unreasonable conduct. You can see from this subsection that in order for relief to be granted, the alleged wrongdoer, the first person, must have engaged in actual or threatened detrimental conduct, and when they did so, they must have believed or suspected that the applicant or any other person may have made, proposes to make, or could make a disclosure that qualifies for protection under the part, and that belief or suspicion must have been the reason or part of the reason for that conduct. Detriment is defined very broadly in another section, to which I will return. This section gives rise to the question of what is a disclosure that qualifies for protection under this part. The answer is found in the opening section, Section 1317 AA. Next slide, please. A disclosure of information by an individual will be a qualifying disclosure if the matters set out in subsections 1, 2, and 3 of this section are met, which you can hopefully see on the screen. I apologise for the small font. These subsections concern who makes the disclosure and to whom they are made. You'll see with respect to sections 1 and 2 that various concepts are inbuilt, including eligible whistleblower, regulated entity, and eligible recipient. Each of these terms are defined in various other sections, which I've referred to in your handout, but for present purposes, it's sufficient to note that they're defined very broadly, such that any current or former employee or supplier, or even their relative, can be an eligible whistleblower. A regulated entity includes any company, and an eligible recipient includes officers or senior managers. It's also important to note that these requirements do not need to be met in respect of subsection 3 disclosures to legal practitioners for legal advice on the section. Next slide, please. You'll see, if you've got very keen eyesight on this slide, subsections 4 and 5, which concern the subject matter of the disclosure and must be met in order for a disclosure under subsections 1 or 2 to apply. Assuming the disclosure is made by and to an eligible person, it will be a qualifying disclosure if the discloser has reasonable grounds to suspect that the information they are disclosing concerns misconduct, which is defined in section 9, or an improper state of affairs or circumstances, which is not defined, or indicates that the regulated entity engaged in an offence or contravention set out in the section, or represents a danger to the public or financial system, which is not defined. There are some exceptions to this. Personal work-related grievances that do not concern a contravention of the actual victimisation contravention, which I'll come to, are not qualifying disclosures under subsections 1 and 2. In looking at this, it's important to bear in mind to what end the concept of qualifying disclosure is used. At first blush, one would be forgiven for thinking that by reason of the heading of the section, disclosures qualifying for protection under this part, a qualifying disclosure must be made in order for someone to obtain any relief under the part. Not so. As we've seen from section 1317 AD, it's the belief or suspicion of the alleged wrongdoer as to the making of or possible making of a qualified disclosure that's the critical matter. So where the question of whether or not disclosure is a qualifying disclosure or not comes in is in the context of an inquiry into the alleged wrongdoer's state of mind. The third critical matter identified by the full court was the reverse onus provision in section 1317 AD 2B. Next slide, please. The applicant bears the onus of adducing or pointing to evidence that suggests a reasonable possibility of the alleged wrongdoer engaging in detrimental conduct. And if that onus is discharged, the respondent then bears the onus of proving that the claim is not made out. Therefore, the respondent will need to disprove first that they held the alleged prohibited belief or suspicion, and secondly, that if they held it, that it was not the reason or part of the reason for the detrimental conduct. It's important to note that this reverse onus only applies where a person seeks relief under section 1317AE. So it will not apply where, for example, ASIC seeks a declaration and civil penalties in respect of any of the contravention provisions. The approach from the case law to date has been to apply a test for the purposes of a section 1317 AD1 claim, as summarised on the next slide. Can we go to the next slide, please? Thank you. After the applicant discharges the burden on detrimental conduct, the respondent must then prove that when it engaged in that conduct, it did not believe or suspect that the applicant subjectively possessed grounds for suspecting misconduct or an improper state of affairs, which would objectively constitute reasonable grounds for that suspicion. And if it did hold that belief or suspicion, that the belief or suspicion did not form the reason or part of the reason for the detrimental conduct. It's not necessary for the respondent to have believed or suspected that the grounds for the applicant's suspicion were objectively reasonable. There are a couple of other subsections of section 1317 AD about which you should be aware concerning accessorial liability and liability of a company for actions of a third party, but I won't delve into those today. Next, we'll turn briefly to the contravention provisions. Next slide, please. There are three types of contraventions set out in these provisions, each of which are offences and civil penalty provisions. First, section 1317A(e)(1), that of disclosing the identity of or information likely to lead to the identification of a person who has made a qualifying disclosure in the circumstances set out in that section. Next slide, please. Secondly, section 1317AC(1), which is a contravention of actually causing detriment to another person, which you can see is expressed in very similar terms to section 1317AD1. And thirdly, next slide please, section 1317AC2, which is threatening to cause detriment to another person because a person makes or may make a qualifying disclosure. Note with respect to this threatened victimisation contravention, in contrast to the similar provision under section 1317 AD, it requires a mental state of intent or recklessness as to the second person fearing that the threat will be carried out. There is also an offence provision in section 1317 AI in respect of certain companies failing to have a whistleblowing policy and failing to make it available to officers and employees of that company. Officers or employees of companies can also be accessorily liable for contraventions of actually or threatening to cause detriment to another person. It's important to remember, though, with respect to these contraventions, that in most circumstances, only ASIC has standing to apply for a compensation order or pecuniary penalty order by virtue of section 1317J of the Act. So these provisions I've just referred to won't assist individuals seeking relief themselves. This is apparent when we turn to the next relevant decision, which is Mount and Dover Castle Metals Pty Limited, which was handed down in February this year and was the first decision of the court resulting from a final hearing on the post-amendment provisions. If you're following along on the handout, we're now heading into lessons from the case law. To explain the facts of this case, Mr. Mount was the former CEO of Dover Castle Metals. He recorded his opinions on the alleged mismanagement of the company and improper behaviour of two of its directors, including allegations of fraud, in two so-called whistleblower reports, and emailed them to two other directors. He was dismissed within 3 weeks of starting his role shortly after he did this, and he claimed that it was because of the disclosures that he'd made. His claims included a confidential information and actual victimisation contravention, as well as a claim for relief using section 1317 AD, all of which were dismissed. Justice Katzman found that Mr. Mount had no standing to seek orders for compensation or pecuniary penalties for the contraventions, but that the court could make declarations with respect to them under the Federal Court Act. In any event, Her Honour was satisfied that the company's reasons for dismissing him did not include any belief or suspicion that he had made a qualifying disclosure, finding instead that the reason was the belief that he'd engaged in misconduct. A further significant aspect which arises from this case is an issue as to the way in which an applicant frames his or her case. Because Mr. Mount alleged that the respondent had engaged in a confidential information contravention over one disclosure, he needed to prove without the benefit of the reverse onus provision that he had in fact made that qualifying disclosure. Given the court's conclusion that he had no standing to seek relief under the part with respect to that claim, it's unlikely that there'll be many cases where individuals allege a contravention of that provision together with a Section 1317 AD claim, but it does serve as a reminder to consider carefully how a case is framed by an applicant and its consequence upon the reverse onus. This is particularly so if the applicant brings other claims in addition to a Section 1317 AD claim on the same facts, which might require it to positively prove matters which would otherwise be subject to the reverse onus. For example, if they brought a common law or adverse action claim. We'll turn now to the next two decisions of the court that have proceeded to final hearing, and I'll introduce the facts of both of them before discussing the lessons that we can take from them. The next case is Reich and Neo Metals, which was handed down 1 week after the decision in Mount. Mr. Reich was a former employee of Neo Metals who alleged that he had made 6 qualifying disclosures to the company. He alleged that the company, via its board of directors, engaged in detrimental conduct by deciding to make his role redundant, dismissing him, rejecting a claim he made for time in lieu, and then bullying and harassing him after he made 2 of the alleged disclosures. His claims were all dismissed. Justice Futrell rejected the proposition that a qualifying disclosure needed to be made in order for a claim in respect of Section 1317 AC or AD to succeed, finding that it was not an element of the cause of action under either section. However, His Honour observed that the fact of a qualifying disclosure having been made is relevant to the inquiry whether a person who engaged in detrimental conduct held the relevant belief or suspicion. Evidence that a whistleblower had information which, if disclosed, would qualify for protection could be relevant to that question. An applicant may benefit then from alleging that a qualifying disclosure was in fact made, as it provides a firm basis for the alleged wrongdoer's belief or suspicion. Bear in mind that if you act for an applicant and the applicant does not allege that a qualifying disclosure was actually made, the applicant will nevertheless need to identify what matters are said to give rise to the respondent's belief or suspicion as to the potential making of a qualifying disclosure. The final decision is that of Jackson and Heart Research Institute, which was handed down 2 months after Reich in April this year. Professor Jackson was a former employee of the Heart Research Institute who began to question and make complaints in relation to the financial management and practices of the institute with respect to grants allocated to him, and the board then resolved not to renew his employment contract. He alleged that that decision constituted a detriment when the institute believed or suspected that he proposed to make or could make a qualifying disclosure. Unlike the situation in Mount or Reich, Professor Jackson apparently alleged that the relevant belief or suspicion was held with respect to a possible rather than an actual disclosure. His claims were dismissed. Justice Raper held that the decision not to renew his contract did not constitute a detriment, and that in any event, the Institute proved that it did not hold the alleged prohibited belief or suspicion, and even if it did, it was not motivated by that in its decision not to renew his employment contract. The lesson we gain from both of these cases concerns how a respondent disproves the state of mind matters where the detrimental conduct is engaged in via the board, as was alleged in both Reich and Jackson. In Reich, Justice Futrell was prepared to assume without deciding that where Mr. Reich discharged his evidentiary onus on detriment, the company bore the onus of proving that none of the directors held the prohibited belief or suspicion. If one member of the board did so, and it formed the reason or part of the reason for that director's decision to vote in favour of the resolution, the applicant would succeed. Observations with which Justice Raper agreed in Jackson. Next, we gain some understanding of the meaning of the term improper state of affairs or circumstances. While Justice Futrell in Reish did not need to reach a definitive conclusion on the meaning of the phrase, His Honour remarked that where a putative whistleblower has information of a type which does not obviously or readily engage or assist the regulatory functions of ASIC, APRA, or another Commonwealth authority in relation to the regulated entity or its related body corporate, the alleged wrongdoer may not have reason to believe or suspect that disclosure of that information would qualify for protection. Justice Raper agreed with this in Jackson also. Wright and Jackson together emphasise that with respect to the reason for the conduct, it's the substantial and operative reason that matters. That is the or a reason which moved the person to engage in the detrimental conduct, not just a factor that the person considered but discounted. Finally, the two cases make clear that it will be difficult for a respondent to disprove that it had the prohibited belief or suspicion without direct evidence as to the absence of that alleged belief or suspicion. But the mere fact of evidence from a decision maker that the prohibited belief or suspicion was not held will not be enough to discharge the onus. It is necessary to have regard to all circumstances and evidence to reach a conclusion about the person's state of mind. The alleged wrongdoer need not appreciate the legal quality or character of the disclosure in order to fall foul of the provision. The final key matter we see from the case law is on the limits of detriment. I mentioned that detriment was defined very broadly. Next slide, please. You'll see the breadth of the definition on this slide. In Mount and Dover Castles, Justice Katzmann considered that the intention of Parliament was to capture any disadvantage and that the list was illustrative only. The courts in both Reich and Jackson agreed with this. However, in both of those matters, some conduct was found not to amount to detrimental conduct. In Reich, the respondent unsuccessfully argued that the rejection of Mr. Reich's claim for time in lieu for overtime worked could not constitute detrimental conduct because he had no legal entitlement to have this claim approved. Justice Futrell observed that an arbitrary, capricious, illogical, irrational, or unreasonable reason for rejecting a claim for time in lieu may constitute a detriment because the relevant policy was not applied to an employee in accordance with its terms and the merits of the claim. However, His Honour held that on the facts of the case, the rejection of Mr. Reich's time in lieu claim fell within the discretion of the C-suite approval process under the company's policy, and the reason for rejecting his claim was not arbitrary, capricious, or unreasonable, so it did not amount to detrimental conduct. In Jackson, Justice Raper rejected Professor Jackson's argument that the Institute's decision not to renew his contract of employment constituted a detriment. Her Honour noted that there was no option to renew within the contract, but rather the parties were negotiating a new contract on different terms. Her Honour found that a loss of a chance to negotiate a further contract may comprise a detriment, but in the circumstances of this case, Professor Jackson did not in fact lose a real and valuable opportunity to negotiate a further contract by reason of what had transpired to that point, because the negotiations with respect to that contract had paused by reason of intervening events. From this, it's important to be aware that not every negative decision or outcome by an employer will suffice to comprise detriment for the purposes of the section. Next slide, please. With only a handful of authorities considering these provisions in detail, the area is ripe for development. In particular, developments on questions of the limits of detriment, when grievances will fall within the personal work-related grievances exception, the extent to which state of mind issues must be proven, and the limits of the concept of an improper state of affairs or circumstances remain to be seen.
Thank you very much, Victoria. Justice Rangier is running a tight ship here. So by virtue of that, we won't be inviting questions, but we will be inviting you to engage in discussion with Victoria and all of us after the event concludes. We'll turn now to our second speaker, Mark Feltham, who is in Victoria. He's going to speak about the thorny issue of multiple decision makers in adverse action claims, and in particular with respect to the discharging of the reverse onus with respect to them. Mark was called to the bar in 2004 and was appointed senior counsel in 2021. He is in Aitken Chambers in Victoria. Mark has a wide practice in industrial and employment law and acts on all sides. He also appears in class action employment law disputes. Part of the reason perhaps for the aptness for him being chosen, but about which we were unaware, is that he is the father of 3 teenage children. And from that, all of us know that the identification of the decision maker, who they are, whether they remain it, and the extent to which they hold quorum is often a moving feast that gives rise to many challenges. And also he speculates as to whether his spare time is the wrangling of the children or in fact the retreat to chambers and to the curial chamber. But in that respect also he tells us that he otherwise is becoming less bad at tennis, maybe not as accomplished as Victoria in the sporting, but no doubt he is seeking to better that. So we're grateful very much, Mark, for your presentation, and we look forward to hearing from it.
There is a tight ship here, so I'm going to make sure I've got the timer on. Thank you, Justice Raper. One of the seminal cases, certainly recently in multiple decision makers, is Wong and the National Australia Bank. 2022 Federal Court of Australia full court at 55, and I was in that case and lost. And on my way in, I did ask Justice Dowling if it was okay if I complained about the outcome of that decision, to which he said it's not okay. And that kind of got rid of a lot of what I wanted to say. But I'll try and think of something. Adverse action is one of the most prolific areas of the Fair Work Act, and I've got no doubt in this court and the federal jurisdiction generally. And I want to talk today about multiple decision makers where a particular decision is impugned under the legislation, primarily through sections 340 and section 351 of the Act, which prohibit engaging in adverse action or discriminating against a person because of, that's the language, a prohibited reason, and those reasons are wide and varied. Importantly, and everyone has this drilled into them as industrial practitioners, section 360 effectively says that if action's taken for a particular reason, if the reasons for that action include the prohibited reason, and importantly, there's effectively a reverse onus by operation of section 361, and so that agitates the minds of practitioners and judges in these adverse action cases. Usually the question is, has that reverse onus been discharged? The basic approach to that task is well established. It's set out in the Board of Bendigo case in Barclay, and also the CFM, EU and BHP Coal. It's a question of fact, which is answered in light of all of the facts established in the proceeding. And usually the court has said, understandably, but it turns out it's become a little bit unhelpful, direct testimony from the decision maker, which is accepted as reliable, is capable of discharging the burden. Now, in that case, there was in fact a single decision maker, but it almost erected a standard and introduced language that doesn't appear in the Act, decision maker. That's not what the Act says. The Act is a person takes action because of a particular reason. And as a number of authorities show, there isn't always a single decision maker. And that's where some of the problems arise. And it was eloquently summarised by Justice Sharif in a recent case, Lang O'Rourke and Halley, 2024 Federal Court of Australia 1323, where His Honour said this central question that I just raised is more problematic. I think His Honour was putting it kindly, where there is either no single decision maker or where the relevant acts or conduct are the product of a collaborative or other group-based decision-making process, which is more and more common these days. However, much earlier in 1979, Justice Smithers had said in Wood and Lord Mayor Councillors, it is a fallacy to say that any state of mind to be attributed to a corporation must always be the state of mind of one particular officer alone. So that has been a principle in place for a long, long time, but I think, to be fair, forgotten. And for a while, it was always assumed that there was one person that would be wheeled out as the person who made the decision, and any contribution leading that to that decision was not always taken into consideration, although still at times it was. And what the full court said in Wong was it is necessary to examine the state of mind of the human actor or actors who, alone or together, caused the corporation to take the action that it did. That's Justices Katzman, Charlesworth and O'Sullivan. So there are broadly two types of scenarios where this arises in general. The first is where there's ostensibly one decision maker with the authority imbued in that person by the organisation's policies, procedures, contractual obligations and the like. And that person is assisted and provided information by others, as is often the case with a very senior person who doesn't get down into the details and relies on other management for that. I'll come to that. The second type of example is where there's a committee that makes the decision, or, for example, a board. Now, when 7 or 8 people on the board make a decision about what to do, who is, to use the language of Barclay, Chief Justice French and Justice Crennan, the decision maker when there's 8 people? So that gives rise to some difficulties as well. Now, at some point, the involvement, intervention, activity of someone who is assisting the decision maker, I'm going now to the first type of example, at some point that level crosses a threshold so that person's mind is also one that is interrogated for the purposes of determining whether the reverse onus has been discharged. And let me give a couple of examples to illustrate how that plays out in practice. In the Wong case, the final decision maker about the termination of the employment of Miss Wong, who was a relatively senior-ish manager in the at the NAB, was affected by a very senior person, Miss McLeod. Now, she was not around day to day, and she relied on and was informed by, as to what was going on, her subordinate, who in fact supervised Miss Wong, and his name was Mr. Arnott. And it was Mr. Arnott that had the day-to-day supervision of Miss Wong, and he was the one to whom she addressed most of her complaints, which was the exercise of the workplace right. Almost none of them, if any, were addressed to Miss McLeod, who was the ultimate decision maker. Now, the two reasons that Miss Wong was terminated in the main, I've got to be careful here because my opponent is now on the bench and I can see him looking at me very carefully. We didn't agree necessarily on everything in this case. The two main things were her behaviours and a very significant overrun on a very important project for the NAB. Now, Miss McLeod knew generally that Miss Wong had some problems with her behaviour and knew generally that there was a cost overrun on this important project. But Mr. Arnott knew in much more detail the behaviours of Miss Wong and gave a lot of that detail to Ms McLeod. He also knew in much more detail the extent of the cost overrun, the numbers, how many millions over it was, and his view about the extent of Ms Wong's culpability. Now, Ms McLeod did not interrogate to any significant degree the extent of Ms Wong's culpability in that project and accepted mainly what Mr Arnott said. While she had her own view about Ms Wong's behaviours, she also accepted as largely true Mr Arnott's own views and experiences of speaking to others of Ms Wong's behaviours. And in the end, the full court did find that Mr Arnott, obviously Ms McLeod was the decision maker in the Barclays sense, but the full court also found on appeal that Mr Arnott level of involvement, I mean, there was no question that he was involved. He drafted the termination letter as well, quite happily, I think. And but his level crossed the threshold such that it became important, necessary for his mind to also be interrogated. Now, as it happened, his evidence was able to discharge the onus, but if he hadn't have been called to give evidence, that would have created a serious problem for the bank, who almost certainly, I think I can confidently say, would have lost had he not been called. Another case that I'll briefly mention is a decision of Justice Snowden in Pilbara and the University of Melbourne, 2024 Federal Court of Australia 1140. In that case, it was a university had made a decision to change up its reorganise or change up the structure of the way that it was going to teach the faculty of biology. And there was a faculty head, there was a department head, there was a head of school head, and there was a dean. And there was a lot of discussion by the faculty head and the school head about changing, I came up with a change plan, and that meant the applicant's position was made redundant and she was terminated. And there was direct addressing in the discussions about what would happen to the applicant's role. Now, the dean, all the dean did was approve by various discussions that change plan. What flowed from that after was a matter for the people running the faculties. And His Honour concluded that that was not enough to cross the threshold. I find that there is a conceptual distinction between circumstances that animate adverse action, which is something that needs to be forensically examined in terms of discharging the onus, and circumstances that bear only contextually upon the visitation of that adverse action, which His Honour said is not something. So that's not necessarily an easy line to draw. Now, this issue has been dealt with in a number of decisions, including in Wong and in the short sort of 3-page paper which is available for those who are subscribed. I go through a number of those decisions. But the level of influence has been broadly described as indispensable, material, essential, significant, plainly important, major. Now, if there were no judicial officers in the room, I would say this is a very unsatisfactory state of affairs and needs to be cleaned up. But there are, so all I'll say is that it's somewhat imperfect for practitioners to grapple with which particular test do we apply ourselves to. To some degree, they're all pretty similar, but I think at some stage this area is ripe for something definitive to emerge from the court. Courts have repeatedly said that they don't want to give a definitive test. I note with interest that Justice Sharif in the Halley case almost accepted that this was a particular issue and did say at paragraphs 294 to 295 that perhaps the organising principles about how this might be expressed will arise from principles of aggregation and attribution of knowledge and intent that are in corporations law. And so that's a bit of a watch this space. The second type of scenario where this occurs is committees. And this is, in some respects, a little bit more vexed because there's no authoritative decision that says this is who you must call where there's a committee. If it's a majority decision of 4-3 on a 7-person committee, do you have to call all 4? Is it enough to call 1 or 2? If it's 8, do you have to call all 8? So there's no definitive answer. In Roberts and General Motors Holden, which is a full court of the Industrial Court, Justices Smithers, Woodward and Evatt said that the courts may need to analyse the motives and roles of individual members of a committee, and noted that some members with improper motives may overbear or mislead others. And in Voitsberger and Pine Rivers Shire Council, Justice Evatt said that the employer must usually call evidence from a majority of committee members. And finally, I note that in Greater Dandenong City Council and the ASU 2001 FCA 349, or it was a full court of the Federal Court, Justice Merkel in fact drew an adverse inference, scarily, in relation to a failure by a council to call evidence from all the members of the council who voted in favour of the decision. Now, at the end of the day, it's going to come down to the facts. If someone on the committee did all the talking, did all the persuading, had the strongest view, or 1 or 2 people, which is often the case, you at the very least are going to have to call those people. And if it can be established on the documents or with that evidence that there were 1 or 2 people who said nothing and were happy to go along with the flow because that wasn't their particular area of interest and they were focused on other things that the organisation was doing, you might be okay. But you can have another scenario where you have 2 or 3 boisterous members on a committee or a board who are called, but discovery produces a diary note of a person on the committee who said nothing, but left a note that said, concerned about this employee continually going on parental leave, emoji, frown face. Now, that would suggest that there's a problem about what, for example, if the case was adverse action on the grounds of marital or parental status or having a child, that would be very problematic. And so that really calls attention to the importance when preparing a case and giving advice to clients about analysing forensically, very carefully, the evidence and who it is that is said to be a decision maker having regard to the authorities. Justice Snowden in the Pilbara case did make some observations of the pleadings and the way the case was opened. Without being critical, he did observe that it was quite difficult on the pleadings and in the opening to discern who it was alleged to have made the decision or been one of the decision makers, and who was it said by the employer to have been that person. And sometimes it can just emerge in the evidence. You might have someone who gives evidence saying, well, yeah, actually, now that I think about it, it was me that was responsible ultimately for that decision. I didn't really see it that way at the time. And then bang, you've reached the threshold of someone who was essential to the decision-making process. But very careful consideration needs to be given when drafting a pleading and defending a pleading about who is the decision maker. And it's not always so easy because sometimes a plaintiff employee or an applicant employee won't know who the decision maker was. They may get a letter from their manager saying your employment's been terminated, and only may emerge later that the supervisor of the mine site gave all the names to the ultimate mine manager who effected the termination tainted themselves by wanting to make sure all the union delegates were on that list. And you don't know that until discovery. So it is tricky, but it's something that needs to be front-ended, as they say, in adverse action. Adverse action cases do require quite a bit of work up front to make sure that they're run properly and not given nasty surprises on day 4 of the hearing. If anyone wants to ask me any questions afterwards or ask about any of the cases, only the ones that I was successful in, then you're more than welcome to. Thank you.
Thank you very much, Mark. Now, Gillian has embraced the admirable and necessary task of considering recent federal court authority regarding the court's judicial review jurisdiction. And what a remarkable task that is at almost 6:30 in the evening. We're very grateful to her for that. Now, Gillian was called to the bar in 2010 and is a barrister at Murray Chambers in Adelaide. And she was appointed senior counsel in 2022. She has a broad civil practice in dealing with commercial disputes, employment in industrial matters, professional disciplinary matters and appeals. She has a strong regulatory practice acting for the Fair Work Ombudsman and ASIC, and she regularly appears in employment-related disputes for all possible participants. Now, she also refers to her spare time, but unlike Mark, she refers to her being the chair of the South Australian Bar Association's Women at the Bar Committee, a number of other committees. And what she has identified as a professional goal for the next 12 months is to learn to say no in relation to committees and to be leaned upon by Justice O'Sullivan in South Australia to present at these kind of seminars. But I have no doubt, based on the subject matter that she's talking about, the very warm welcome and praise she'll receive from her talk, that she will be coming back next year. What I would remind you in relation to it is that there is the SIG box, which you can, because we're a remarkable modern national court, we have a SIG box which has all these presentations on it, which you can now look at on your phone. There is a, in each court, thanks to our court officers, there is the, whatever it's called, that you can scan, like you can for a menu in a restaurant, and have all the papers. So please note that it's there, and it also will remain accessible for a period. Anyway, thank you, Gillian, over to you. And I understand Justice O'Sullivan is timekeeping.
He is indeed, and thank you, Justice Raper. I acknowledge that in Adelaide we're meeting on the traditional country of the Kaurna people of the Adelaide Plains, and I acknowledge their continuing relationship with the land. I pay my respects to elders past and present. It's always a little daunting to have to follow on from our interstate colleagues at these seminars, and I thank Victoria and Mark for their excellent presentations and their use of the time. And I have promised multiple justices that we will finish on time. And so there may be times where I skip over matters a little briefly. Through the QR code is an outline of the structure of my presentation with the relevant case citations and legislative references. Now, despite the fairly central role that the Fair Work Commission plays in our workplace relations systems, the mechanisms of review of its decisions are not always well understood. Sometimes that's because we've conquered the Fair Work Act. It's enormous. We've dabbled in the Corporations Act. Why would we go over there to judicial review, which has lots of scary case names against the Minister for Immigration? So my aim tonight is to demystify how the review mechanisms operate, with a focus on some of the key questions that you should be considering when you're contemplating a review. And I'll look briefly at 3 recent cases. It's useful to start by looking at appeals within the Fair Work Commission, because that will assist in demonstrating the difference between those appeals and the judicial reviews of its decisions that are conducted by the courts. So the general source of appeal rates for persons aggrieved by a decision of what in most cases is a single member of the Commission is found in section 604 of the Fair Work Act. And this will capture appeals from unfair dismissal applications, approvals of enterprise agreements, or applications to vary awards or enterprise agreements. It's important to remember that appeals to the full bench of the Commission are not appeals as a right. You need permission. And generally, by operation of section 604 subsection 2, if the Commission is satisfied that it's in the public interest to grant permission to appeal, that permission must be provided. Doesn't mean that other cases are not also given permission to appeal, but it prioritises those in the public interest. Parliament did set some further limitations in some specific types of cases, however. So, for example, in an unfair dismissal application, in an unfair deactivation or unfair termination case, the Commission must not grant permission to appeal unless it's satisfied that doing so is in the public interest. And in those same cases, appeals based on errors of fact may only be made on the ground that it is a significant error of fact. And in the paper, I've given you all of those case references, legislative references to the provisions where there are slightly different terms for seeking permission. So once you've got your permission to appeal, how is that appeal to be conducted? Appeals within the Commission are by way of rehearing, which for most of us is the familiar form of an appeal. They're not do-overs, they're not appeals de novo. They're appeals where, generally speaking, consideration is given to whether the decision was affected by error. If there's errors of law or there's wrong findings of fact, the appellate court will effectively try the case again on the evidence that was before the court below. And within the limitations that exist when conducting an appeal on the record, so affording appropriate respect to the advantages of the trial judge, the Commission on Appeal has all of the powers to make findings and orders that were possessed of the usually single Commission member at first instance, and is obliged to give the judgment it considers ought to have been given. And so as such, you can have an appeal allowed and a different substantive order made. You might have a increased compensation amount, or someone who was unsuccessful in establishing an unfair dismissal may succeed on appeal and obtain reinstatement or compensation. That appeals within the Commission are by way of rehearing was confirmed by the High Court as recently as last month in Helensburgh, Cole and Bartlett. So after you've exhausted your appeal rights in the Commission, a party may then seek judicial review of the Fair Work Commission's decision. And relief is different to that which is available on an appeal. It includes the constitutional writs. There are two ways in which applications for judicial review from the Commission may be brought. First, you can go to the original jurisdiction of the High Court. Those cases are very likely to be remitted to the Federal Court for hearing. If you use the High Court's jurisdiction, the rules give you a 6-month limit from the date of the decision if you're seeking certiorari, so to quash the decision. The most commonly used option is to bring the application in the original jurisdiction of the Federal Court. So section 39, capital B, subsection 1 of the Judiciary Act provides this original jurisdiction to the court, and it's reinforced by the terms of the Federal Court Act itself, where, including by section 23, the court can make the orders it thinks appropriate, including the issue of writs. Within the Fair Work Act, section 562 gives this court jurisdiction in relation to any matter arising under that Act, and section 563 expressly provides the power, for example, to grant writs of mandamus and prohibition, as well as injunctions and declarations. Now, certiorari is not mentioned. It sneaks in as an ancillary form of relief that comes along with seeking mandamus or prohibition. Now, who are you going to be before if you come to the Federal Court? Under section 20, usually you're going to be before a single justice of the court. Unless the matter is of sufficient importance that the Chief Justice directs the matter be heard by a full court, or your commission decision included the President, who is a sitting justice, in which case Section 20, subsection 2 sends the matter straight to the full court. So you've worked out how to bring your application, you're in the court. It's important to keep in mind that judicial review is not an appeal. Because the court's jurisdiction on a review is more limited, the court is not diving into the merits. It is not making substantive orders for relief. What the court can do is quash the decision below and order that the Commission take certain steps, such as remitting it back to determine according to law. So you may find that absent a settlement, even if you are successful on a judicial review, that is not the end of the litigation. Now, the full court has recently given some fairly direct reminders of the difference between an appeal and a judicial review. I've provided you with the references in the paper to Cube Logistics and the decision in Twomey. So in keeping with the court's more limited jurisdiction, it's important when you're framing your application for judicial review to identify and establish a jurisdictional error. So this is a much narrower field than the types of errors that might be effective on an appeal. Jurisdictional error is broadly concerned with how decisions are made rather than the merits of the underlying cases. And an error by the Commission that is within its jurisdiction is not going to be enough to establish a jurisdictional error and obtain relief. So, for example, as observed by the High Court last month in the case of Helensburgh Coal, an error about the standard of appellate review to be applied on an appeal, where the nature of the appeal, so that it is a rehearing and that you're looking for error, has been correctly understood. If they've gotten the standard of review wrong, so decided it was a discretionary decision rather than an evaluative decision, it's an error within jurisdiction, which is not going to sound in relief on judicial review. And that's because the Commission in such a case correctly understood the nature of its function, being to identify error, but identify the wrong error. It would be different if it had misapprehended the nature of its function, so conducted a de novo appeal. And we see from this that the court's powers are engaged on a review where there is an error which has the effect that the decision has not been made according to law. So essentially there's no decision at all, ends void. The categories of jurisdictional error are not closed, and identification of whether there has been an error requires an understanding in each case of the limits imposed by the relevant statute, including whether there's any express or implied conditions on the making of the decision. So as said by the High Court now 30 years ago in Craig in South Australia, relevant errors can include where a tribunal falls into an error of law, which causes it to identify a wrong issue, asks itself the wrong question, ignores relevant material, relies on irrelevant material, or in some circumstances makes an erroneous finding or reaches a mistaken conclusion, so that the exercise, a purported exercise of power that has occurred in the decision, actually exceeds its authority or powers. Other relevant errors include failing to observe procedural fairness, and where a decision is legally unreasonable and therefore irrational. So what we used to call Wednesbury unreasonableness. Now, it's not enough to just establish an error. You need to also establish that the error was material to the decision. The High Court recently, in a decision of LPDT and the Minister for Immigration, and the citation is in the paper, provided a really clear and useful statement as to jurisdictional error and how the question of materiality works in very frank and practical terms. And I would encourage everyone to read the first 16 paragraphs of that decision. The court pointed out that in some cases, the nature of the error is such that it will be jurisdictional regardless of the effect. So cases of apprehended or actual bias on the part of the decision maker. In other cases, the potential for an effect on the decision is inherent in the nature of the error, so unreasonableness in the final result. But in most cases, consideration will need to be given to whether or not the error was material. And the question to be considered is whether there is a realistic possibility that the decision, in fact, could have been different if the error was not made. Now, the High Court described this threshold as neither demanding nor onerous. It's a backward-looking exercise. You're looking at what decision was made and how it was made, and it made comments on often all that need to be done is the tendering of the relevant reasons for decision. You're looking at whether the decision could have been different, not would it have been different. The High Court is warning against descending into the merits. The qualifier is whether there was a realistic possibility that the decision could have been different without the error. That excludes fanciful or improbable possibilities. And what must be shown to meet the threshold will ultimately depend on the nature of the error. So a denial of a procedural fairness, so failing to put someone on notice of an issue or a fact, may fairly readily result in an inference that if they had been given notice, that applicant would have called further evidence or made a particular submission such that materiality can be fairly easily found. And the High Court emphasised that a court considering the question of materiality must be careful not to slide over what it accepted was a not always clear line between judicial review and a merits review. So having found your way into court and framed your grounds for, or identified your grounds of jurisdictional error, what relief is available to you? The first thing you need to remember is in judicial review, relief is sought against an officer of the Commonwealth who's making the relevant decision. So do not forget to include the Commission as a respondent on your application. Now, you're usually going to have a submitting appearance, but these are things that never are front of mind, but are actually very, very important. And because the court's not engaging in a merits review, you're looking at much more limited relief. And the primary relief is the constitutional writ. So you're almost always going to be looking for a writ of certiorari, so quashing the decision or decisions that were made by the Commission. You'll usually seek a writ of mandamus, requiring the Commission to hear and determine the original application according to law. So there's that difference with an appeal. On an appeal, the court, in most cases, will go on to redetermine the issue itself. Whereas on judicial review, they're sending it back down to the Commission to do it properly. Sometimes you might seek a writ of prohibition, prohibiting the Commission from continuing to perform certain acts. You may also see injunctions or declarations, but your primary relief is going to be certiorari and mandamus. And it's important to remember you're effectively declaring or having a decision removed. So what then sits in its place? So if you're coming out of the full bench, don't forget that you might need to also seek to quash the first instance decision. And if you've been unsuccessful at first instance and then been refused permission to appeal by the Commission, you can't just ignore the full bench's decision not to grant you permission to appeal. Justice Meyer recently made that fairly blunt observation in Hancock and DP World Proprietary Limited. And this may mean, depending on the nature of the errors in question, that you need to point to an error in the decision to refuse permission to appeal. So you need to think carefully about what it is that you're seeking to undo and have you gone far enough to get the ultimate outcome you want. Relief is also ultimately discretionary. And while you would usually expect that if you establish a material error, relief will follow, you still need to have regard to the question of utility. So is there still work to be done if the decision is quashed and remitted? And you may need to have regard to delay. particularly in Section 39B applications where there's no actual time limit on bringing applications. So the High Court says 6 months if you want to quash the decision, but there's no actual time limit in the coming into the original jurisdiction of the federal court. So just don't let it lurk around on your desk for too long, because that might be a factor which, even if you ultimately establish error, means that you're unsuccessful. Now, I indicated at the outset that I would speak about some recent cases, and I'm conscious of not running over my allotted time, so this discussion will be brief, and I've given you the references, and I encourage you to have a look at the decisions themselves. The first decision I'll speak about is the full court's decision in Cube Logistics Rail Proprietary Limited and the Australian Rail, Tram and Bus Industry Union, which was earlier this year. In that case, Cube sought to vary with retrospective effect 2 enterprise agreements to remove what it claimed was an ambiguity or uncertainty. And it did so on the basis that the agreements did not reflect the common intention of Cube, the relevant union, and the employees who voted on the agreements. So what was an issue was whether there was a common understanding that the rates specified in a particular clause of 2 agreements were loaded rates to which award penalties were not applicable. That meant there needed to be consideration of what occurred during the negotiations, what was communicated to employees who then voted on the agreements, and how the agreements were in fact performed. Cube was unsuccessful at first instance, was granted permission to appeal, but lost on appeal before the full bench, and came to the full federal court on a judicial review application. And at the heart of that application was a contention that the commission at both levels failed to engage with a substantial and a clearly articulated argument. This first arose based on how the Deputy President at first instance treated a document which formed part of Cube's submissions, which was described as a roadmap. And there's a detailed description in the judgment, but essentially it contained a number of propositions that Cube submitted would have to be reconciled in order for the Commission to make any finding that it had agreed to pay the award penalties in question. Looking at the first instance decision, the full court held the propositions in the roadmap were clearly relevant, required careful consideration by the Deputy President, but that the reasons demonstrated an inadequacy of consideration of those submissions. And then in the full bench on appeal, the full bench held that the roadmap was, these are its words, fundamentally misconceived and not relevant. I think the full court described that as strong language. The full court held that that characterization of the roadmap by the full bench was in error, and that while the way the roadmap was presented in the Commission might have been misconceived or said to be misconceived, it was necessary for the submission to be dealt with because it was both relevant and significant. Failing to engage substantively with such a submission is, of course, liable to be the basis of a jurisdictional error. And the full court held in this case that the full bench overly narrowed its field of inquiry, and that spoke to a misunderstanding of the relevance of the submission. And so by treating the roadmap in the dismissive fashion that it did, the full bench was held to effectively fail to consider a key aspect of Cube's case, and it fell into jurisdictional error. That was obviously material, and the full court quashed both the full bench and first instance decisions and sent the matter back to require determination of the application, but only in respect of one of the enterprise agreements, because Cube was held to not have standing in respect of the second. The second case that I will very briefly touch upon is Retail and Fast Food Workers Union and Woolworths, another decision of the full court of this year. It's a case where the applicant union sought to review a decision by the full bench approving an enterprise agreement, and they did so on the basis that the Better Off Overall test had not been passed in respect to part-time employees, and the full bench on the union's case incorrectly found that it was. A number of grounds of review were pleaded, including legal unreasonableness and a denial of procedural fairness, and none of them succeeded. I'm not going to take you through the elements of the decision, but it's a useful discussion about where errors might fall to be errors within jurisdiction as opposed to jurisdictional errors. And I would recommend it be read before you frame and bring any judicial review applications, because it provides very clear examples of how you might fall into the traps of a quasi-merits review rather than the required assessment of the lawfulness of the decision itself. Now, the last case that I will speak to you about tonight is the High Court's case of Helensburgh, Cole and Bartley, handed down last month. Helensburgh, Cole, in the midst of COVID in 2020, was restructuring its operations at a time when it had three sources of labour: 2 separate contractor workforces and its own employees. And its restructuring plan reduced both types of workplaces, contractor and employee workforces, and ultimately 90 employees were made redundant. I think about 40% of the contractor workforce was no longer required. 22 employees brought unfair dismissal applications in the commission, and the employer contended that the terminations were genuine redundancies. There was a somewhat convoluted course through the commission. There was an initial decision of the commissioner in favour of the employees that they were not genuine redundancies, went up to the full bench, who overturned that decision, sent it back to the commissioner, who again found in favour of the employees that they were not genuine redundancies, went up to the full bench, and the full bench upheld that decision. The key facts surrounding this restructuring were that the terms of the contracts with the labour hire providers were such that the employer wasn't obliged to request workers from them. So there was no ongoing immediate commercial obligation to use the contractor workforce. The work of that contracted workforce was not specialised, and there was essentially no easily identifiable reason why it couldn't be performed by the workers who had been made redundant. And there were enough jobs performed intermittently by contractors for all of the redundant employees to be redeployed. So the commissioner considered, in undertaking the assessment under Section 389 of whether it was genuine redundancy, considered the feasibility of the employer insourcing the contractor's work, as well as considering the nature of the work and whether it was specialised. And upon considering that what was essentially an operational change to bring outsourced work in, and whether that it could be reasonable to redeploy the redundant workers into those roles, the commissioner determined it would have been reasonable to so deploy the affected employees. And so the commissioner has held that it's relevant to consider whether an employee restructuring its operations within the enterprise to create an available position was reasonable in all of the circumstances. That decision was upheld on the second appeal and subsequently upheld by the full federal court on a judicial review application where Helensburgh sought to quash all 4 commission decisions. And the High Court upheld the full federal court's decision. The question that was ultimately before the High Court was, of course, not about the underlying merit. It was not about whether these were genuine redundancies. It was about whether the Commission's determination that it could consider the operation of the employer's enterprise for the purposes of assessing whether at the time of the dismissal, the employees could reasonably have been redeployed into a position to perform work being done by the contractor workplace was the correct construction of Section 389. And the High Court, it's an important discussion of the construction of that section in the judgment. The High Court held that the Commission could consider the manner in which the enterprise's workforce was used and effectively inquire into whether changes could have been made to make a position available. That the question of whether it was reasonable in all the circumstances to redeploy the employees was not limited to looking at jobs vacant at the time, included looking at whether work or demand for work within the enterprise that could have been performed by that or those employees. Observe that while the redeployment must be reasonable in the context of the enterprise, it must be reasonable in all the circumstances, which is a very broad consideration. And confirm that the statutory test in section 389 requires an employer to consider a hypothetical scenario where it would be reasonable in all the circumstances to redeploy its redundant employees, including in roles not currently open. Now, I understand the importance of reading my bench. His Honour tells me that I have slightly less than 10 minutes left, but there are a shuffling of feet that tells me it's time to finish up. I hope I've been able to do what I set out to do, which is slightly demystify the nature of the review processes. And I thank you all for your attention.
Well, can I tell you all that it's remarkable, isn't it, the skill with which the speakers today have kept within time. Justice Rangi will be pleased. There's no reptilian suggestion of growing within the space here, but rather the exercise of skill. But in addition, you would join with me, wouldn't you, in noting with respect to each of our presenters, Victoria, Mark and Gillian, that they have presented insightful, educative presentations, and one's about topics which represent significant aspects of this national practice area. That's why they were chosen, no doubt. And what they reveal, of course, is the constant evolution of this organic area of law, both by legislative change and the movement along the jurisprudential arc. Now, please stay and express your gratitude to the presenters, but also please stay and talk about them with your colleagues. Refreshments are available in each of the most hospitable registries, which are as part of this seminar, and in particular, of course, Justice O'Sullivan and Justice Darling and our colleagues who I can see in Melbourne are there. What I would like to say finally is not only to thank our presenters, but to the court staff that has made this possible. The seamless nature of it, of course, doesn't reveal the toil that exists behind it. In particular, Leanne Lyons, who is Justice Rangia's associate, has spent a considerable amount of time working with, you can imagine, the digital practice team, our court office staff, the comms team, and all those, the caterers and everyone that sit behind it. So the court is very grateful to the assistance of our court staff as always. So please join with me in thanking everybody and join us outside. The SIG box is up for you to download now the papers.